Someone missing? No? Everybody here? Yes, means missing or here? Okay, 4 minutes to go. It's better to start early. I'm sure you have taken in enough. You want to... I'm sure you'll be very pleased if I skip my part. You can go home or something. Today, I'm going to speak to you about onus of proof and procedure at trial. Tomorrow, I'm coming to speak about fact-finding and judgment writing. I hope I can do all this today in an hour and a half, I hope, if not less. But before I do that, Lorraine must have given you some documents I asked to be forwarded to you, okay? Otherwise, how is it going so far? Sorry? You're learning, are you? Okay. A lot, is it? Information overload. Yeah. But at least it begins to make sense. It fits together. Now, onus of proof and procedure at trial. In our practice, civil practice, and it will be no different really from what happens in the magistrates' courts. The right to begin, meaning who is the party who will start, is linked to the party on whom the onus rests. So, as a trial judge, as a judicial officer, your concern when you walk into court, when the case begins, is who has the onus of proof. Ordinarily, it's the plaintiff who bears the onus of proof. And how do you determine what the onus is? Now, the basic principle, as we all know, I'm sure I'm just repeating what we all know, is that he who alleges must prove. And the party who initiates the suit is what we call in our parlance, legal parlance, the parties that is dominus litis. Therefore, the one who carries the risk, and I like this expression, the Americans put it that way, the risk of non-persuasion. Who is the party who carries the risk of non-persuasion? And that is the party who has the right to begin. Risk of non-persuasion means if I don't adduce the evidence, if I don't make out the case, I have not persuaded the case. So I carry the risk of non-persuasion. I brought somebody to court, I must come and prove my case. So I carry the risk of non-persuasion as the plaintiff. Now, the party who bears the onus must present sufficient evidence, what we lawyers call the prima facie evidence, which, unless the defendant presents rebutting evidence, will entitle him or her to the judgment of the court. So, I'm explaining two concepts in one. There is the onus, the burden of proof in the strict legal sense, and then there is the evidential burden. Now, the onus of proof never during a trial shifts. There is debate, academic debate about that, but that's for another day. This is a very practical course, so we remain with the practical side of it. The onus never shifts during the course of a trial, but the evidential burden shifts. So if the plaintiff has presented sufficient evidence to make out the prima facie case, and if, as the defendant, I don't come and rebut that, meaning I have failed to discharge the evidential burden, then judgment will be given against me. So after the plaintiff, the evidential burden moves to the defendant. Unless, of course, and I'm sure this was dealt with you during the course of the program, unless, of course, at the end of the plaintiff's case, the plaintiff has failed to produce sufficient evidence to place me on my defense. That's now the absolution that you would have been talked about. So if the court is satisfied that there has been sufficient evidence laid, and the judge overrules any application for absolution, and the defendant does not testify, then in a civil trial you are in trouble. Ordinarily you are in trouble. So a party might have, through cross-examination, sufficiently punctured the case of the plaintiff that at the end of his or her case, there is really no case for the defendant to answer. In that case, absolution is granted. Now, in the action proceedings, this is what I have just described to you. In motion proceedings, as you would have heard, it's slightly different. The similarities end here. The applicant will start addressing the court. As you know by now, those proceedings are by way of affidavit. So all the affidavits would have been delivered. The court comes in here only to hear oral arguments. So he starts off with the applicant to address the court, after which the respondent will address the court, and the judge ordinarily reserves judgment unless he or she gives judgment immediately extempore. But the question about not enough evidence presented, that doesn't arise in motion proceedings. Because, as I will demonstrate to you tomorrow, and as it might have been demonstrated already, motion proceedings are intended for the resolution of undisputed facts. Motion proceedings are not intended for disputes of fact, although disputes of fact may arise. And I'm sure you were told, based on the Plascon evidence test, how the court deals with that. But what I said about the plaintiff or the dominant litis parties being unable, perhaps, to present sufficient evidence to place the other on his or own defense, that does not arise in motion proceedings. So that is really the important difference. Now, there is another sense in which I want you to be careful about what I've said so far about the onus never shifts. And when you pick up a good textbook on evidence, I normally keep one like this all the time with me, Hoffman and Zeffert, but there is a longer version, as you all know. There is academic debate about that issue, that the burden actually can shift during the course of trial depending on who is alleging what. And to some extent, that's true. Now, let me give you an example to demonstrate this. If somebody sues somebody for non-payment of money, if says Damaseb owes me $100,000, he has failed to pay me, the debt has become due and payable, I have made demand, he has failed to pay. That's your cause of action for an ordinary payment of a debt. And then Damaseb says, yes, but I paid you the money. When we met in the disco in July, I paid you the money. Now, you must be careful about where a person alleges payment of a debt. In that event, the person who alleges payment must prove he paid. So if I admit the debt, and the only issue is whether or not I have paid, and I allege that I have paid, I must prove that I paid. So in that sense, the onus will rest on me to establish that I have actually paid. Now, academic writers will suggest that the onus has never really shifted. All that has happened is the evidential burden. And I think both are correct. Both are correct. So be careful in the context of payment of debt, that there are circumstances in which he who alleges non-payment has only a certain obligation, and that is to prove advancement of the money. And he who alleges that he has paid, he must adduce enough evidence to establish that he has paid the debt. So be careful about that important distinction. Now, the burden of proof is the ordinary civil standard on balance of probabilities. So as you are sitting in court, presiding in a case, you must always bear that in mind, that the burden that the plaintiff bears in a a civil case is different from that which he or she bears in a criminal case. The criminal case is the R versus Blom, we all know. If there are other reasonable inferences, if all other possible inferences have not been excluded, you cannot convict. That's R versus Blom. Be careful about the civil one. The civil standard is different. The civil standard is more probable than not, or more likely than not. Now, the important case which we have adopted in our courts, a judgment of the Supreme Court, Pupkewitz. I'll give you the citation to that. I'll give the notes to Lorraine early in the morning for you to be given. But the case is Govan versus Skidmore, 1952, Volume 1, SA 732, brackets N, which means Natal Decision at 734. 1952, 1, Volume 1, SA 732, N at 732. In finding facts or making inferences in a civil case, it seems to me that one may, as Wigmore conveys in his work on evidence, 3rd edition, paragraph 32, by balancing probabilities, select a conclusion which seems to be the more natural or plausible conclusion from amongst several conceivable ones, even though that conclusion be not the only reasonable one. Emphasis, even though that conclusion be not the only reasonable one. So you see the immediate distinction with R versus Blom. You must exclude all other reasonable inferences before you can convict. In a civil case, there may be 5 or 6 possible reasonable inferences. And you do not have to exclude all of them in order to find for the plaintiff. You choose the inference that is the most reasonable, the most probable. That's what you follow. So the civil standard is very important. I really want you to understand that one. For example, I'll give you a crude example that I always give when I demonstrate this point. That I go back to our example of Damaseb owing you money, but I'll just exaggerate the figures. You say that I owe you $1 million. You gave me this loan in a disco while we were dancing, having fun. That's when you gave it to me, the 1 million. And I say, I never borrowed any money from you, I don't owe you anything. And you say you lent me this money in the year 2010, and the idea was that I was going to pay you back immediately. Now you don't sue me in 2011 or 2012, you wait until 2018. You sue me for $1 million. And one of the reasons why it appears on the papers you are suing me is that in the meantime I have sued you for $50,000, say. And now your claim in court is you say, Damaseb owes me $1 million which he borrowed 6-7 years ago. Now how will you look at the probabilities in this case? Is it probable? We are not related. I borrow money from you, substantial amount of money. You take 7 years to sue me. You only sue me when I am the one who sues you. You never made any demand for that money at all. What are the chances? What are the chances? What are the probabilities that your claim against me are valid? You see, that's how you look at probabilities. Human nature works in a particular way. We are unrelated. I owe you a substantial amount of money. You don't even demand that money, but in circumstances where I have made a demand against you, that's when you sue me. Probability suggests I probably never owed that money. So you do not need to be convinced beyond reasonable doubt that I don't owe you the money. But what are the probabilities that somebody who is owed money by somebody for a substantial amount of money does not claim that amount of money within a reasonable time? So that's how you work out probabilities. So be careful about how you look at the onus of proof in a civil case. And as I said, contrast it with the test in R versus Blom. Now, having dealt with the onus, you now know, you sit as a judge in your court, you know where the onus rests. You have read your pleadings. You know that so-and-so is claiming an amount of money from so-and-so. The pleadings in the defense, I'm told that he says he paid the money back. So you are already on guard. You want the plaintiff to prove the fact that the money was advanced. If the defendant has conceded and admitted that the amount is proved, your focus has already moved. You want to hear what the defendant wants to say, because that's really the crucial thing. So with that, you start your trial. Now, what is your procedure at trial? You must look at rules 99 to rules 101 of the rules of the High Court. I don't really want to go into them. Read them with your time. That sets out the procedure for how your trial is conducted. Now, the basics is in the magistrate's court. The plaintiff begins. After the plaintiff has led his or her witnesses, has been cross-examined, the defendant leads witnesses, are cross-examined. After each witness is the re-examination and the trial closes. That's your normal trial, how it is conducted. No different from what it is in the High Court. But again, the parties can always choose how they want to conduct the case, but be guided by rules 99 to 101, 102. 102 deals with the record of the proceedings. So please, 99 to 102, I want you to read on your time. I want to place emphasis on the evidence, the part of the evidence. As you probably were told already now by Advocate van der Westhuizen, because in a different context, Ms. Bassingway dealt with motion proceedings where the affidavits are your evidence. In action proceedings, we have, by amending Section 39 of the High Court Act, empowered the Judge President to make rules for the reception of evidence, including providing for witness statements. So the main method by which evidence is received in the High Court is by way of a witness statement. Rule 92. Read the entirety of Rule 92 and understand it. It is unnecessary for me to take you through each and every aspect of the rule. On witness statements, I'll highlight the important parts. So a witness statement is prepared, and during the case management process, as I'm sure informed, the parties agree on when the witness statements are going to be submitted, and then at the trial, the evidence in chief is led by way of a witness statement. And it is the main method through which evidence is received. Exceptionally, as the rule tells you, a person may amplify the witness statement. I do it very rarely. The party must really satisfy me why I should allow them to lead additional viva voce evidence in addition to the witness statements. But how is the witness, but before I get to that, I also want you to read Rule 25(2)P of the rules. That allows also for evidence to be received by way of an affidavit. A witness statement is not given on affidavit. I do not know if it was highlighted to you. But it's not given on affidavit. There is a procedure for how the witness statement is received, and I will highlight that to you now. But there is provision made for the possibility of evidence being received by way of affidavit. And we do that in certain cases. Say, for example, a motor vehicle accident case. Somebody has sued another one in a motor vehicle collision case. The defendant did not testify. The matter comes up for judgment in the motion court, unopposed. We usually receive that evidence on affidavit. So the panel bidder will prepare an affidavit who says, I examined this vehicle. It was damaged beyond economical repair. I'm an expert in motor vehicle evaluations and assessments, and I can assess the damage at such and such value. And we receive that evidence usually by way of an affidavit. So in limited circumstances, especially where we do not expect disputes to arise, evidence can be received by way of affidavit. I just wanted you to be aware of the existence of Rule 25(2)(p) under the rules of the court. Now, what are the formal requirements for the witness statement? As I said, Rule 92 governs witness statements. It will have been clear during the case management process at what stage the witness statements are going to be filed. The court will have set an order directing the parties to file the witness statements. But at the end of the witness statement, which has been prepared by the party, look at Rule 92(2). There is a formal requirement that the witness must state that he or she believes that the facts stated in the statement are true to the best of my knowledge. But that's not an affidavit. It just says it's true to the best of my knowledge, but it's not under oath by way of the jurat that we always do of an affidavit. So it is clear from the rule, if you read it, that a witness statement need not be under oath or affirmation. In fact, it is preferable that it is not under oath. The only requirement is that the maker of the statement believes that the facts in the statement are true to the best of his or her knowledge. And the obvious rationale of the rule is that witnesses must not be unnecessarily exposed to the risk of perjury or making a false statement under oath, and to be held to their statement until they come to court and confirm the statement under oath on the record after the admonition had been given by the trial judge. Now, before a witness statement is received, there is an admonition that the judge administers. I do not know if it was mentioned to you, was it? So that is very important. So what you do is that the witness comes in court. I do not know how the other judges do it. The way I do it is that I expect the witness to read the statement into the court, him or herself. That's how it should be done. That's the proper way to do it. But before he or she reads the statement, I warn them by way of the admonition, and I emphasize, do you know that the moment that witness statement has been read into evidence, that is your evidence under oath and in chief? Do you accept that? Yes, my lord. And it's on that basis that the witness statement is read through. And as I'm sure you would have been told, the witness statements already will have indicated what are the annexes that the witness will lead together with the witness statement. So all those annexes, it's a laborious process for the 2 or 3 hours that it happens, but after that, there is really great sense in why it exists, because it so much expedites things. And at the end of the witness statement, I will always ask the witness, is there anything that you want to add to what you have said? Is there anything that is inaccurate in what you have said? Are you sure that there is nothing you want to add? Are you sure everything that you have said in here is accurate? After that, of course, the cross-examination continues. So remember that I want you to read the Rule 92 very, very carefully. And the sequence of the witness statements is governed by Rule 92(3). In what sequence are they going to be received? And ordinarily, it's really the plaintiff, his or her witnesses, starting with the plaintiff himself. It's only in exceptional circumstances where it's a person other than the plaintiff will start, or the person other than the defendant. But the court has a discretion, and Rule 102 of the rules of the High Court will tell you the circumstances in which you can vary. I've dealt with the admonition. Now, if a person does not provide a witness statement, what are the consequences of a failure to serve a witness statement? If a party fails to serve a witness statement, it may not call that witness to give oral evidence unless the court grants leave on good cause shown. So if you fail to provide a witness statement, you must show good cause for the court to be able to admit a statement that you have not previously provided. Rule 93.5 deals with that. I've never had a situation where I allowed a witness statement to be allowed which the other side did not serve. I would either refuse to hear that witness with appropriate orders that I make, or if I'm really satisfied that it was impossible for that witness statement to have been filed, I will adjourn the proceedings, allow the witness statement to be filed, order cost against the party, and then postpone to a future date so that the other side has the opportunity to read through the witness statement and to prepare themselves. So you should not lightly grant a party a condonation to lead into evidence a witness statement that was never led. Now, cross-examination is governed by Rule 93.6. Read that very carefully about how you deal with a witness statement. Now, after the witness statement has been read into the court by the witness, the lawyer has probably asked whether he or she can amplify. Maybe you refused the obligation to amplify, or you have granted it and amplification was done. Then the cross-examination happens on the witness statement, based on what the witness has read into the court. And that forms part of your record as the evidence in chief. Now, cross-examination, as I'll point out to you tomorrow, when we do the fact-finding and judgment writing, is both a right and an obligation. A party has a duty to cross-examine on matters which he or she wants to place in dispute, or they want to challenge the credibility of a witness on. Remember that. The other thing I want to mention about the witness statement, and this is very important, because it is a party's evidence in the trial, it is subject to the ordinary rules of evidence. So a witness statement must not contain inadmissible evidence. A witness statement can only admit relevant evidence, and both the court and the lawyers have an obligation to bring to the attention of the judge those matters in the witness statement that canvass irrelevant or inadmissible evidence. So the ordinary rules of relevance, admissibility, apply to a witness statement. So if I see something in a witness statement as a judge, which none of the parties have picked up, which is hearsay evidence, I'll tell them, that is hearsay evidence, I will not admit it. It's your duty. Because inadmissible evidence cannot be admitted in court for any purpose. And remember the next point that I make. In our law, in our practice, and it applies to both criminal cases and civil cases, admissibility of evidence is a matter of law, not of discretion. You don't have a discretion to admit this or that evidence. The party must be able to point either to a rule of the common law or a statute in order to have evidence admitted in court. So you cannot produce leading evidence in a witness statement, and that will be the same, not so, if you are giving viva voce evidence. We don't allow leading evidence. Same applies in a witness statement. We don't allow inadmissible opinion evidence. We do not allow hearsay evidence. We do not admit evidence that goes to previous character unless it falls under similar fact. So always be guided by your textbook on the law of evidence. All those rules apply to a witness statement. And of course, after the witness has been cross-examined, on the witness statement, re-examination happens. Now, there is something about witness statements you should be very careful. Since that often enough in practice in court that it's necessary that I point this out to you. So when I come as a witness in a court and I read my witness statement, I take ownership for what I have said in that witness statement. I do not necessarily take responsibility for what another witness has said in his or her witness statement. Now, what lawyers often do is they will say, Mr. X, will you deny what Mr. Y is going to come and say in his witness statement? You can already see the obvious problem of that. What if Mr. Y comes and he doesn't own up to what he has said in the witness statement? So I normally don't allow that. I will say, first, you must promise me that Mr. Y is going to come and testify. And number two, Mr. Y will come and repeat exactly what is in his witness statement, because he has not come and said that yet. Otherwise, you'll be drawn into very unnecessary and irrelevant cross-examination. So this witness will be cross-examined on something Y is coming to say about in his witness statement, and then Y comes and says, no, it's not true. Now look at where it has taken you. Entirely waste of time. So be very, very careful about how you deal with that. So if the lawyer can promise you, one, that Y will come and testify, number two, Y will repeat what is in that witness statement, then only would I allow him to cross-examine the witness on that basis. So I thought I should remember that, mention that. Now, I mentioned about admissibility of evidence as being a question of law and not of discretion. I want you to read the judgment of the High Court, Rally for Democracy and Progress. Rally for Democracy and Progress versus the Electoral Commission of Namibia and others. 2013, Volume 2, page 390, it's a High Court judgment. 8429, paragraph 242. 2013, Volume 2, 390, High Court 429, para 242. The other thing that I want you to remember about witness statements and evidence generally is that even if through some inadvertent error, inadmissible evidence has been admitted in court, it is your duty as a judge, indeed as a judicial officer, to ignore that evidence when it comes to deciding the case. So if hearsay evidence was admitted, which should not have been, don't base your judgment on hearsay evidence because it's inadmissible. Because, and I repeat, you have no discretion in the matter. If the law says that certain items of evidence is inadmissible, that's what it is. You could not admit inadmissible evidence. Now, during the course of the trial, you'll, as happens also in the magistrate's court, there are objections. That will happen in regards to witness statements being led, it will happen to cross-examination, it will happen to re-examination. So how do you deal with objections when they occur during the course of a trial? Certain golden principles. A judgment of the court must be based on relevant and admissible evidence. And the relevance is a function of two important things, as every good textbook on civil evidence will tell you. The first one is the parties' pleadings, which means the matters the parties placed in issue and the substantive law applicable to the matter guides relevance. So the allegations that the parties have made in the particulars of claim that have been made in the plea or in the replication, that is your guiding line, and that determines relevance, guided, of course, by what is the substantive law which governs the matter. Evidence which goes either to support a party's claim or undermines that of the opponent on either count, including credibility, will generally be relevant. So, if I am trying to cross-examine somebody to show that he is untrustworthy witness, that goes to relevance. It's relevant material, as long as it arises from the pleadings, that this is a witness that should not be believed because in the past he made a contradictory statement on the same issue. It's a relevant issue. And I repeat, a legal conclusion arrived at by the reception of inadmissible evidence is therefore liable to be set aside on appeal. And I make this point because this guides you to deal with objections. Because the only way in which you can deal with an objection is if you know what are the relevant issues in the case, determined by the substantive law and the pleadings of the parties. So an objection by a party must be assessed against the backdrop of the pleadings and the relevant law that guides you on the matter. You see, the other thing that I want to mention to you about objections, and this happens very often in trials, during trials, and I will be surprised if you don't confront it in criminal cases in the magistrates' courts. Lawyers tend to try and save their clients from embarrassment. So when a certain question has been posed to a witness, they try to object. Now, it has two functions. One is you should be careful. If it is a relevant objection, or obvious case, say, of hearsay evidence, that's obvious. But sometimes they do it unnecessarily. And experience has taught me, in some cases they do it because they want to alert the witness, so that the witness knows they are entering dangerous ground. So they will stand up and say, "My lord, I object." How can my learned friend ask the witness that kind of question? It is, the truth is this and this, so the witness already gets an idea what to say. So if I am not satisfied about the merit of the objection, what I ordinarily do is I ask the witness to go outside. I go and ask him or her to stand outside the court, and I ask him, "What is your objection?" So, "No, my lord, this and this is the objection." "But why bother? Why bother?" "Because you will have the opportunity during re-examination to put it right." And I mention this to you because it's important. I see this also when we see appeals coming from the magistrates' courts in criminal matters. Be careful about objections, because most of the time they are unnecessary, and they relate to matters that can be cured during re-examination. So, but if there is a merit in the objection, which is obvious, you should be able to entertain the objection. So during trial, and when objections are being made, be careful about certain aspects of your trial. One of them I have already mentioned, and I will soon discuss the hearsay rule to you because it's misunderstood based on some of the things that I see on appeal. I want to highlight a few topics you will confront regularly during your trial, and usually which relate to objections. The first one will be hearsay evidence. I'll go into a bit of detail on that. The second one is computer evidence. I want you to look at the Computer Evidence Act 32 of 1985. I'll give you the notes. You will see the reference. We also discussed that in the Rally for Democracy case at paragraph 242. People will just come in with a printout from somewhere and say, "Yes, my lord, yes, the evidence, I got it from a computer." We have rules about how evidence from a computer is received. So I mention this thing because they are happening every day in court. Unless both sides have accepted that is admissible evidence, don't accept as evidence in your trial anything somebody just comes and produces because it comes from a computer. The other one is, I already mentioned, inadmissible opinion evidence. I'll deal with that briefly. Important one, I will also deal with what we call the parole evidence rule. The other issues, of course, are the usual leading questions. It jumps up. That's a leading question, my lord. That's a leading question. Please just read any textbook on evidence. You will know what is a leading question. Parties trending to raise new issues in re-examination. Those are the sort of things you will confront with every day during a trial. Somebody jumps up and says, no, my lord, I want to object because he's raising a new issue which was not raised in evidence. The chief on cross-examination, you have to be satisfied if the objection is merited. I mention these things to you because these are the things I want you to take special note of, because that's what you will experience every day during the course of a trial. And then a repetitive evidence. People come and somebody cross-examines somebody for 20 minutes on the same issue. I put it to you, I put it to you. So your duty, our duty is to give a person a fair trial. There is no right in our constitution to a lengthy, meaningless trial. There is no such right under the constitution. If a person has put a question to a witness which has been answered, there is no point that question being repeated, repeated, and repeated until hopefully the witness is destroyed, as they think. So if you are satisfied that the witness has answered the question, that the record already demonstrates that a sufficient reply has been given to an answer, usually do it very gently. My usual style is, counsel, I think we can move on to the next point. You get the idea already, they move on. But don't allow a witness to be badgered, a witness to be unnecessarily confused, to be asked unfair questions, and so on. That's our duty, is to make sure that we give a fair trial, but not that the trial degenerates into a circus, where a witness is being drawn out until he or she hopefully faints one day in court. You can justify to his or a client that you saw. Most of the cross-examination I see in court could have been finished, if it lasts 1 hour, it could have been done in 15 minutes. But lawyers go on and on and on. And our duty is to understand the limits to which you can put witnesses to such lengthy and unnecessary cross-examination. Opinion evidence is another one. Be very, very careful about opinion evidence being brought in through the back door. The basic rule of evidence is that an opinion of a witness is irrelevant unless it is expert evidence. You can't come in court and say, my lord, me and that gentleman were involved in an accident. In my opinion, he was negligent. It's irrelevant. It is the court's duty to decide who is negligent. A witness's opinion as to who was negligent is irrelevant. You may receive expert evidence on, for example, the state of the road, the skid marks, whether it tells a story. Somebody may come and give a scientific evidence to prove so-and-so. If I look at the skid marks, if I look at where the cars were positioned at the time, if I look at the damage to this car, in my expert opinion, it means so-and-so must have been driving on the wrong side of the road. That's expert evidence. But Mrs. Shibanga standing alongside the road and coming to court and say, all she can say is that, my lord, I saw 2 cars on Independence Avenue. I saw one driving this direction and the other one. That's admissible evidence. But about who was negligent, in my opinion, he was wrong. That's opinion, inadmissible opinion evidence. Be very, very careful about that. Ordinarily, the only evidence that the court must receive by way of opinion is expert opinion evidence. But the expert must be properly qualified and his or her credentials proved. I'm sure you were taken through the process. There is a process through which a person's credentials as an expert is received. I mention this because it's very important. It happens every day where inadvertently, over time, you allow a witness's opinion to take over the place of evidence. Be very, very careful about that. Now, in the context of the civil trial, There is an important case of Minister of Basic Education, Sport and Culture, Minister of Basic Education, Sport and Culture, versus Vivier, nomine officio. It's a judgment in the Supreme Court. It's 2012, Volume 2, 2012, Volume 2, Namibia Law Report 613, Supreme Court, as I said, 626. There the court discusses the circumstances in which opinion evidence by an expert should be received. And what are the limits? Even expert evidence, there is a limit to expert evidence. And the basic rule is that you allow expert evidence only on a matter on which the court does not have the means to itself determine the matter. Expert evidence must help the court. Expert evidence must relate to a matter on which the court does not have expertise itself. That's the extent to which you receive expert evidence. Now, there is another important judgment I want to reference to you, and it's a criminal judgment, but it demonstrates the point. And it's State versus Ramgobin, State versus Ramgobin, R-A-M-G-O-B-I-N, R-A-M-G-O-B-I-N, 1986, Volume 4, 86, Volume 4, SA 117, Natal decision. It's 163 to 4. Ramgobin involved a dispute involving tape recordings. Now, in that case, the court refused to accept the testimony of a person who said she listened to the record extensively and offered herself as a knowledgeable on the issue. The court said it was in just as good a position to do that itself, and that the typist's evidence was irrelevant and inadmissible, which a witness is not allowed to give an opinion as it is the prerogative of the court. Now you can see the point why. Now just because somebody says, I listened to the tape of the recordings, and therefore I'm the expert. So, well, I can listen to the tape myself. Apart whether the tape was working properly, that could relate to expert evidence. But about what is on a tape is a question which the court is just as good a position as the person who transcribed from the record to come and testify about. The other thing you must be very careful about, and it happens regularly in our courts of law, and objection will often be taken, and if objection is not taken, it's your duty to deal with it, is that an interpretation of a document, both of a statute or a contract, is a matter of law, not of fact, and therefore within the competence of the court and not a witness. Read this judgment, KPMG versus Securifin, KPMG versus Securifin. It's a South African judgment, very important. 2009, Volume 4, 2009, Volume 4, SA 399 at 409, para 338, para 38. Now this, I say important for this reason. People will come and fight over a contract. Say, my lord, we entered into a contract, and a written contract, and we agreed, this is the contract. It says X will do this, Y will do that. And then they want to tell you what paragraph F in the contract means. That is not permissible. We want to look at Section 29 of any act, say the Land Reform Act or the Companies Act, and says, my lord, I want you to decide this because, in my view, this section means that. That's a matter of law. What a contract means, or what a statutory provision means, is a matter of law, not of fact. And witnesses can deal only with fact, not questions of law. because those are matters for interpretation by the judge. So, in the case of, in the British case, Lord Tomlin, I will cite the case to you, said, in British Celanese Limited, British Celanese Limited versus Courtaulds, Courtaulds Limited, Courtaulds Limited, British Celanese versus Courtaulds Limited, is 1935, 52 RPC 171. It's a House of Lords judgment. I will provide it to you. The court says, that's the principle of the law we apply, that when it comes to interpreting a document, an expert is entitled to explain the meaning of any technical terms used in the document, but that counsel is not entitled to ask the expert, nor the expert entitled to say what the document means. So if there is a technical term used in the document, that's what the judgment tells us, an expert can be called about that, but he cannot say what the document means. Such an exercise is a waste of time, the court went on to say, and money, as it accumulates a mass of material which, far from assisting the judge, renders his task the more difficult, because he has to sift the grain from the unnecessary amount of chaff. In my opinion, the trial court should make strenuous effort to put a check upon an undesirable and growing practice. Very, very important. So don't allow people to come and tell you about the meaning of a document unless, and through the case management process, it will be clear whether there is a technical term that has been used in the contract about which an expert has been, can testify, but about what the document should mean as a document. Who is the liable party? That's a matter of law, which the court will have to decide at the end of the day. Now, another point I just want to mention to you in passing to be aware of, and I'm sure it was mentioned, is that there are certain rules that govern the manner in which expert evidence is led. Rule 29, I'm sure you have dealt with already. It deals with who may be called as an expert. I want you to read Rule 29 very carefully. And the procedure also spelled out in Rule 29 about the process to be followed to have expert admitted to provide evidence in the court. And most importantly, a provision which never existed in the past, which now exists in the new rules, also in the Rule 29, is a court expert, that the court is allowed under certain circumstances to call an expert itself. I did mention to you when I came the first time that one of the important differences between criminal practice and civil practice is that a court does not have the liberty to call witnesses. But in relation to expert, a special rule has been developed which allows the court to call an expert witness. All of it in Rule 29, going up to Rule 30, please. I want you to read that, including the procedure that relates to circumstances in which the court can require experts to meet and agree on a joint document in order to shorten the process of the trial, and so on. So I mentioned the expert witness because an objection may be taken, because I'm dealing with objection taken during trial. Somebody may say, my lord, that is inadmissible expert evidence, or that the foundation has not been laid for that expert to come and provide evidence. And as a judge, you must deal with that carefully, and you can be guided only by what the rules say. I want to spend a bit of time on two matters, and that is hearsay evidence and the parole evidence rule. When you read the rule on hearsay evidence, and it relates also to criminal trials, is that be careful about reading South African textbooks. The amendments which were brought in the South African law on hearsay do not apply under Namibian law. We still apply the old common law hearsay rule. In South Africa, they amended the legislation to give the court discretion to, in certain circumstances, admit hearsay evidence if it is in the interest of justice or something like that. I think that's the expression. Our law has no such provision. And if evidence is hearsay, it is hearsay. It cannot be admitted for any purpose. It's meaningless. It's useless. So be careful about that. In terms of Section 42 of the Civil Proceedings Evidence Act 25 of 65, that's what applies in Namibia. As far as hearsay evidence is concerned, English law applies as it was applicable on 30 May 1961. That's our law. Sections 42 of the Civil Proceedings Evidence Act 25 of 1965 preserves the common law on hearsay to that applicable in England on 30 May 1961. And I repeat, unless somebody can point to you either to a rule of the common law or statute, hearsay law is hearsay evidence is inadmissible. And we all know, I'm sure, what are the common exceptions to the hearsay, the same ones that we apply in criminal context. Please read up on our common law. Usually use the old textbooks, but I'll give you a handout where you will have the statement of the hearsay rule as it applies in Namibia. Lorraine will provide that to you. Remember this: oral or written statements made by persons who are not parties and are not called as witnesses are inadmissible to prove the truth of the matter stated. That is the hearsay rule. So somebody makes a statement, and remember it says, not party to the proceedings. Not party to the proceedings. Most people misunderstand that. You'll see the objection. They will jump up. You and I sue each other. And then somebody will say, my lord, on this day, Mr. Simpson said this. I say, I object. How? It's hearsay. I say, no, but he is a party to the proceedings. Even if he doesn't come and testify, he may choose not to testify. Mr. Simpson may choose not to testify, but he's a defendant or he's a plaintiff. So he is a party to the proceedings. So what he said outside court is relevant, and it's not hearsay. So it is hearsay only to the extent that it is an out-of-court statement of a person not called as a witness, but who is not a party to the proceedings. That's your classical hearsay rule. And most importantly, it is hearsay only when it is intended to prove a fact in issue and as representing the truth. If the simple point is that evidence is being led to show that the statement was made, I only want to show that the statement was made on this date, and I am not tendering it to prove the fact that it's true or not, then it's admissible hearsay. That's what they say. And again, I will show you in the handout that I demonstrate to you the significance of that statement and the circumstances in which it can be received. I think about 3-4 weeks ago, the Supreme Court again wrote a judgment in the Opindi matter, I think. Look at that very carefully, that recusal obligation thing where Judge Frank wrote the judgment where the hearsay rule is again being discussed and the extent to which statements can be admissible if the only purpose is to demonstrate that the statement has been made, not if it is intended to prove the fact that the statement was made. And you see, it can be very relevant. And take, for example, the criminal context. The fact that a person acted in a particular way could have been induced by what somebody said. Whether or not that statement is true, could have been induced by a statement made by somebody. So for that purpose, it is not tendered to show that the statement is true, but the fact that the statement was made. And that's the only purpose for which it is being admitted. So things that can go to the state of mind of somebody. I might have formed a particular state of mind based on something I heard from somebody. And that statement is being tendered not to prove that it was true, but the fact that it was made to me. Because the relevant circumstance here is my state of mind. That's what is relevant, not the fact that the statement is true or false. But if I say, on this date, somebody made this statement to me, and therefore that's why I did what I did. That goes to explain my state of mind and not made to me. The other one that I want to mention to you is the parole evidence rule. And it's very important, and you are going to experience it day in and out in your civil trials, especially when it comes to contracts. You see, the rule of the law that we apply, the common law of Namibia, which is the common law of South Africa, so common law of England, is that if two people sit together down and reduce a contract to writing, that is, and it was intended to be a complete memorial, as we call it, if it was intended as a complete memorial of the agreement between the parties, you cannot come and produce evidence later on which contradicts what you have said in the contract. So that's the important principle of our law. Read the case of March versus Ulrich, March versus Ulrich, NO, that's nominal or figure, capital NO, and others, 2006, volume 2, NR 616, High Court, paragraph 11. Recently also dealt with in another judgment of von Witz, where the High Court dealt with that, and I think in another judgment in the Supreme Court. But the important principle of the law is that if you are dealing with a contract where two people have sat down, reduced their terms of the agreement into a contract, evidence which is being brought by one of them to try and contradict what they have agreed is inadmissible. And if somebody takes an objection that that evidence must be excluded, you must exclude it. It's inadmissible evidence. Now, in the von Witz matter that I referred to you, which I have not cited, but will provide you with a citation, two people agreed on a sale of a farm. And the contract said that he was going to pay him $200,000 to buy a farm. It was a farm in the south. He will pay $200,000 for the farm, and he was going to pay the purchase price in a particular way. And the contract said all that out. He will pay the deposit on this date, and then he was going to provide a bank guarantee check, and that is the agreement between the parties. He didn't comply with the terms of that agreement. And what does he do? He comes and says, yes, my lord, this is the contract, but what happened is that we met at the service station in Marintal, and he agreed not to take the bank guarantee check, so I gave him the money cash. So the other side said, my lord, I do not know what this man is talking about. Our contract says he must pay me by way of a bank guarantee check, and the money must be paid to the conveyancer. So I refused to admit the evidence and told them that parole evidence does not allow you to lead that evidence. They tried to appeal. I don't know what has happened to it. I think they failed or something like that. But the principle of the point I want to make to you is that when two people have agreed on something, put it down in writing, and agreed on what the terms are of that contract, don't allow them to come and lead other evidence to contradict that which they have agreed. Unless the contract was not intended to be a complete memorial of the agreement, in which case I'm sure Advocate van der Westhuizen would have mentioned when she dealt with pleadings, somebody will normally plead, it was partly written, partly oral contract. Those are different, but you must prove that it was a partly written, partly oral contract. But if a contract is completely written, and that's what the parties intended it to be, tough luck. It may sound tough, but don't allow that evidence to be let in. The other thing you must be careful about, and again, which you must deal with by reference to a standard textbook on evidence, is previous conduct. People will always come and say, look, he owed me money, he didn't pay it. he also didn't owe money, he also once owed money to X and he didn't pay him. But that's previous conduct. Unless it is relevant to this case, don't allow that. Same in criminal case. You do not allow the previous bad conduct of a person unless it meets the test under the similar fact evidence rule. Same applies in civil cases. And there is one case which you will see from the footnote where it appears that a context in which somebody was suing another for product liability, and the way in which he or she behaved on a previous occasion was admitted as relevant to the facts of that case. He previously sold somebody similar product and also a bad product, but that evidence was received in evidence because it met the test of admissibility under the rules of evidence. So be careful about that. So most of the rules that you would have learned over the years and internalized in your criminal procedure practice about the admissibility of evidence will apply to civil procedure. That's the point I really want to make to you about this, with the necessary modifications. Now, finally, what I want to mention is that when the trial starts, one or two things will happen. Both parties will come, and the plaintiff will start, the defendant will come, the evidence will be led, but in some cases, one party doesn't show up. What do you do in those circumstances? When one party shows up and the other one doesn't? I want you to read Rule 98. Rule 98. You can read it in your time, really. And the notes will tell you what happens there. When the plaintiff doesn't show up, what are the kind of orders that you can make? When the defendant doesn't show up, what kind of orders you will make? And you'll see there again, it's very important if you read Rule 98 carefully. It brings out to the fore the point I made to you about the burden of proof. If I'm the plaintiff and I don't show up, the onus rests on me. So the rule gives it the powers to the court to dismiss the claim of the plaintiff because I am the dominant litis party. But say, for example, the defendant doesn't show up. I'm just summarizing to you what is in that rule, but there are detailed provisions. I'm the plaintiff, the defendant doesn't show up. What do you see as the natural lawyer's reaction? What would happen? Sorry? No, I'm the plaintiff. Defendant doesn't show up. And this is an action. Sorry?
If there was a defense, I would move that the defense be struck and then judgment be granted in my favor.
Okay. Okay. Yes. So, but, no, not a bad answer, but I want you to be careful about that. And it relates to owners. It relates to owners. You must be satisfied that the other party has made out their case. Now, if the state of the pleadings is such that you cannot determine the issue without hearing evidence, don't take the issue way out. Don't take the issue way out. Because the fact that one party, especially the defendant, has not shown up, you should never allow the party who bears the onus to just get judgment without the court being satisfied that their case has been made out. Say, for example, it's a defamation claim. That I say that somebody has defamed me. My reputation has been damaged, and I have suffered damages in the amount of $100,000. I will tell you, my judge's instinct tells me, don't grant judgment unless you have heard the evidence. So I had a similar situation in the north about a year ago. Defamation claim, defendant does not show up. I allowed the plaintiff to come and testify, because remember, you must be satisfied that somebody's reputation has been damaged. And number two, that they suffered damage. So you must be satisfied that his or her image was lowered in the estimation of society. That's what the claim is all about. So I would, as a matter of judicial instinct, I will hear the evidence, even in the absence of the defendant. I will hear the evidence of the plaintiff to come and testify about how he or she feels she was defamed. I will hear the evidence about the damage to his or her reputations that she feels she has suffered in the eyes of society. And based on that, I'll then say, look, I have sufficient evidence on the record to show that the reputation, not only that the statement was made, one, but it was defamatory, and that damage was suffered in the amount claim, and only then grant judgment. So the kind of scenario that I gave you is different from what you would have had in the motion court. That's a different sort of situation. Because there, ordinarily, the party would have probably not entered appearance to defend. And somebody comes to court and say, my lord, my lady, I want to obtain judgment because I have issued summons. The defendant has knowledge of the process. They have not entered appearance to defend. And therefore, I want to proceed to obtain judgment. But again, what do we do? In first motion court, it goes back to the principle that I cited to you, an unopposed divorce. You hear the person. You don't just grant divorce. The poor lady will come in, the witness stand, and will say, yeah, on this date, he deserted me, beat me up, doesn't maintain me, and so on. We don't just grant divorce because the other side didn't oppose, because you must hear the evidence. So in actions, as opposed to motion proceedings, be careful about just granting judgment, because especially the defendant has not shown up. If the plaintiff doesn't show up, it's a question of onus and the burden. You are the dominant leaders party. You don't come and present evidence to me, I dismiss your claim. So that's a simple one. But where a defendant doesn't show up, be very careful. The other rule of the law you must be very, very careful about is, just because somebody does not oppose does not guarantee the other side the right to a judgment. The court must be satisfied that the party has made out the case. That's very, very important. So apart from, for example, the divorce case that I mentioned, where you must hear the evidence in order to grant the RCR, when the new law comes into force on divorce, where provision is made for granting divorce based on an affidavit, you can grant affidavit on that basis. There is also a judgment of the Supreme Court where the Chief Justice says there are certain matters where you should be careful about granting judgment without hearing evidence. And it lays, for example, custody disputes about children. Don't just grant relief to one party, especially where custody of children is involved, unless you have had evidence. Because you need to test the versions of the parties, because as upper guardian of minors, the court has an obligation to make sure that it acts to the best interest of the children. So the circumstances in which you will grant judgment in favor of a plaintiff in the absence of the defendant without hearing evidence must be extremely rare. That's my caution to you. And the circumstances in which we do it now is in motion court, which I already referenced, where in motor vehicle accident claims, which are obvious ones, somebody will say the fact of the negligence of the other side, they have not defended, therefore, my lords, the negligence will be taken as established, but when it comes to the damage suffered to the vehicle, the affidavit of the motor vehicle assessors normally would be received on affidavit, and on that basis we grant judgment, and there are limited circumstances in which that is done. So that's what I wanted to share with you today. Any questions? It's 1 hour and 10 minutes, better than I thought. Any other issues from what the others might have said which were not clear to you, which I can help with? So you are ready for action for the 4th of... So if you understand those basic principles from my side, tomorrow morning, I'll take you briefly through fact-finding in the context of a action proceeding, the sort of things you should be careful about when you establish whether facts have been properly established or not. And then I'll briefly deal with judgment writing. And then that will be my contribution to your legal future, or whatever it is. So, thank you very much, and see you tomorrow. What time is it, Lauren? She's gone. What time am I seeing you tomorrow? 9 o'clock. Sure, so early. Okay. There was. Did Lorraine make arrangements with you about the 4th and the 5th? There was an issue raised about whether you should go back to your duty stations or. And I asked her to follow up with Mrs. Alionga. Did she come back? What did she say? She didn't brief me. You don't have to go back. And Korihas, you will be coming to.
I think this is yes.
You will be coming to Vindu. Yes. No, I was just confirming, Lorraine, the arrangements you made for the 4th and the 5th, that they don't have to go back to duty stations until the exam is written, and that the magistrate from Korihas will come to Vindu to write. Okay. And the times and all those things you have agreed. Okay, good. The final parts we'll discuss tomorrow about the logistics. Good luck. Is it not enough? How much time do you want?